Welcome to a new episode of Patent Effect Podcast. This is Mustafa. So we are recording a new episode with my two distinguished friends and colleagues from Ankara. So we are recording this new episode with the support and sponsorship of Simaj, which is a very comprehensive and distinguished legal partner in Turkish IP ecosystem. So my guests will mention about who is Simaj, and also they will mention about their background and expertise. So as I said, I have two distinguished friends and colleagues from Ankara. So Ecem Gökçe Yağmur and Mert Parlar will be together with us in this new episode. So I will introduce them to the record, but maybe before starting, I can say that of course you are reading the title of episode from the explanation of the recording, but we will talk about Bolar Exemption in Turkey, which is balancing and innovation and access to the drugs. It is very, very complex issue, and also new developments are happening in the legal world. And I'm really happy and very exciting to talk and to discuss this topic. It will be also another learning point for me in person, and I hope you will enjoy with this episode with the great insights and information from my guest today. So I don't want to make it long as an intro. So Ecem and Mert here. So can I call you Ecem and Mert without calling your surnames?
Of course.
Yes, of course.
Thank you so much. So we are recording this episode. As you can notice that we are recording this episode in English. So not only for Turkish IP ecosystem, so it can be also available to be listened by our foreign friends, foreign IP friends from all over the world. So Ecem, welcome. Mert, welcome. My greetings to Ankara. How are you?
Thank you very much.
Very good. Thank you. Thank you so much for having us. As you have stated, we are recording this episode in English, and we are hoping to reach out to all of our, global colleagues and associates. I'm sure you're also aware our job, like mostly, it is really global, and being universal is kind of matter to us. So we just wanted to, say our pieces in English. Maybe I can introduce myself and then Mert.
Please, you can start, Ecem.
Okay, great. All right, so my full name is Ecem Gökçe Yağmur, and I'm an attorney at law as well as a trademark attorney based in Turkey, in the capital, Ankara. I've been working in the field of IP since around 2020 now. Around 5 years. I'm a senior associate here at Simaj. I really love what I do. I'm really passionate. And I really enjoy being a part of things like this, mostly because we really love the patent effect and what you're doing, and also because I'm a really big podcast listener. So it's really great to be a part of it.
Before jumping to Mert, I can also say to our audience that I learned recently before starting recording the podcast. We were both, Ecem and me, are from Balıkesir, so we just learned that without knowing each other. We graduated from different high schools, but very, very close, next to next. So it's great information to know today about Ecem and her graduation. Thank you and welcome to our podcast again. So Mert.
Hello again, and thank you very much for having us. I'm really excited as this is our next, as the second time we are recording a podcast. It was really nice and fun and educative, the first one, and I hope this will be the same. I'm an industrial engineer, a colleague of yours, and I've been working at Simaj for like 8 years now, mostly focused on patents. As Ecem said, I like what I do, and I'm also interested in the other fields of IP as well, and I'm lucky that our firm also focuses on every single field of IP, so we all have the chance to learn about different topics. And if I may tell about Simaj a little as well, we were founded in the January of 1994, just before the Turkish Patent Institute was founded. We have celebrated the 32nd year of our firm. We are a firm focused only on IP, and we have the departments related to them, and Yeah, I guess that's all. Yeah.
We are a full service IP firm, like anything you can think about, all things IP, enforcement, litigation, prosecution.
Great, perfect. So thank you to Simaj. Of course, thank you too of with us today in this podcast. But of course, I would like to thank to Simaj because Simaj is continuously becoming a sponsor and supporter of our Turkish landscape report, which we are publishing every year. This year we published the sixth version. That very great impact in the IP ecosystem, in the R&D and innovation ecosystem. Almost all of the big companies who are listed in the report shared themselves by indicating that we are in the first position of this category, we are in the first position of or second position, or we are in the list of top 10 or top 20. It is really good to see this kind of awareness and the taking this IP leadership in a great way in terms of being on the stage. So thank you to Sumaj because you are becoming our main sponsors almost every year. So we can start.
We also like feel, sorry if I interrupted you, we also feel responsible for being, being a part of these kinds of efforts as a one of the like oldest IP firms in Turkey. So it's really great to be here. I just wanted to thank you again. And then I guess we can dive right in.
Yeah, exactly. We should dive into the real topic. So Bolar Exemption, which is a technical issue in the IP ecosystem, it is affecting different countries as well. It's not a national or regional thing, so it's a global legislation. We can say maybe we can start the real definition to make this topic in a balanced way in terms of the knowledge level of our listeners. So maybe one of you can say us what is this Boulder exemption. So what is this and where it comes from?
I just wanted to, start with this very basic question with very basic concepts. I tend to like thinking with concepts. So, like when we think about IP rights, other IP rights, trademarks, copyrights, and patents, we see that, trademarks can be renewed indefinitely, and copyrights has a protection term, and patents they have 20 years, right? We are aware that there's a reason why patents protection term is only 20 years. It's one of the main reasons is to not hinder innovation and to allow the mankind to improve, to invent. But maybe in some cases, there will be a need for further limitations on patent rights. And Bolar exemption is one of those rights, right? So patent term, I am sure your audience is very aware of this, but I just tend to like to think with basic concepts and really understand why these rules are written as they are. So about the Bolar exemption, when you have a drug patent, and by the way, we are mostly in the field of drug patents right now. So you have a drug patent and it's valid and enforceable for 20 years, right? So what generic companies do is they will wait for your patent to expire so they don't get sued, right? However, there will be a need for limitation for instances that are needed to like experiments and trials. These generic companies will need to use the patented subject matter for these types of acts, because otherwise, when you wait until the protection term is over and then start your trials and experiments, obtaining a generic drug license will take up to 3 more years. And there is a gap in between. So if generic companies start to experiment during the protection term, and if we list this as an exemption and not consider it as an infringement, and then generic companies can be on the market with their drugs right after the protection term is over. And it's really important because it relates to public policy, it relates to accessibility to drugs, and overall it relates to public health, actually. So I think it's really necessary, and that's why we see similar rules in various jurisdictions. likewise in Turkey as well, in EU, in USA, the originator country of this rule. And overall, maybe I've explained a little too much, but the aim is to make sure the generic is on the market day one after the post-patent protection. That's what Bolar Exemption means.
Yeah, that's a very good and simple explanation about this exemption. So in Turkish ecosystem or in Turkish pharma industry, it is really important because not almost, all of the drug companies in Turkey are generics. So we don't have drug discovery yet. So we don't have any originator drug company in Turkey. So the Turkish pharma industry needs to wait this patent expire date, but the Bolar exemption will be used by, we can say, Turkish generic companies, not limited with Turkish generic, but all the generics. So, but where it comes from? So it was not a regulation or something, but as far as I know, it's coming from a kind of law case, right?
Yeah. It comes from a case. It would have been cooler if the term Bolar is like somebody's last name or something, like a real person. It actually comes from a case called Bolar v. Roche. Right, so Bolar is the generic pharma company, and it's against Roche, and then they are using the patented subject matter for FDA approval and trials and experiments, and they get sued because that's what you get when you infringe an originator's patented subject matter, more often than not, right? So, and then they get sued, and then their defense is ultimately refused by the US courts. So it's not a successful litigation, actually. But what it does is this case actually led to policy change in the US. The Congress actually enacted a new law to regulate these types of acts, regulate the acts that are needed to be conducted to get a license, get an approval in the US. This case was in 1984. And then after this case, Hatch-Waxman Act was enacted. And that's how the Bolar exemption was regulated, even though this case belongs to the US jurisdiction, which our law system is not really similar. We are a civil law country, Turkey, as well as EU, but we also call it Bolar exemption, or I don't know, in some cases, research exemption.
So we have our own IP law in Turkey. So it was published in 2017, at the beginning of 17. So as far as I know, there is an article on mentioning about not directly Bolar exemption, but saying the similar thing to prevent the generic companies for infringement, not infringing the originator. But how was regulated before the Turkish IP law?
Right. So our IP law actually was entered into force in 2017, and before that we had a decree law. Not really a law, but still, a regulation, right? So actually, under that regulation as well, the Bolar exemption was regulated. The Bolar exemption, it's easier to refer it that way, but research exemption was introduced to Turkish law in 2004, similar to EU. So it is widely accepted and interpreted, maybe even broadly under Turkish law. So it is part of our law and it is really widely accepted.
So it was regulated before the IP law as well in Turkey. So it is most for drug companies, but is there any other industries which are affected with Bolar exemption, or is it just dedicated on the drugs?
Maybe I can answer this question. Actually, it most certainly affects, as you said, the pharmaceutical industry, but sometimes it is also referred to as well in sectors such as biologics or biosimilars, like monoclonal antibodies or like vaccines or cell therapies, or sometimes for medical devices, for agrochemicals or plant production products, and also for veterinary medicines. But as it is not so clear as well, already in the drug sector, it is not so clear in these other industries as well. So it's getting developed on the way, I guess. For example, under the US law, courts accept together with drugs and medical devices, the food additives and the colorings. So therefore, actually, it is required because many developments are happening in different industries. So as different industries need it, they will try to, do the same, even there is no exception in the law. And I think there will be similar cases like Roche v. Bolar, and then there will be similar exemptions in different industries as well, because development cannot be hindered.
Before jumping to the legal and practical implications in Turkish IP ecosystem, I want to make it clear to understand in a correct way, and also to my audience, what is allowed and what is not allowed in this Bolar exemption. For example, if I am a generic drug producer, so I am defining a drug to produce after the patent expire date. But of course, Bolar exemption give me a chance to start some activities 2 or 3 years before of the expire date. But as a generic drug company, what kind of actions can I take without infringing the originator patent, or which actions are not allowed? So how can we divide these actions? I think there are some differences country by country, right?
Yes, exactly. And also, actually, we can say something basic like the intention of the generic producer. What I mean with that is that if you do not intend to, just infringe the patented product, or, if you don't intend to mass product before the patent expiry, then that won't be considered a bad thing, actually. And what we can give examples are for example, the preclinical and clinical testings are allowed. I mean, you can manufacture samples just to try, but you cannot mass product. And you can, conduct toxicology and pharmacological studies, and you can, apply for validations and for regulatory submissions. You can test the shelf lives and the stability, and also you can conduct studies for compliance with local data regulations. But on the other side, if you intend to, make a commercial scale production, or if you stockpile, or if you start marketing campaigns, or start selling, or start trying to sell it, or if you start exporting or give a license, or starting to, do license agreements or license discussions, or if you use them for academic purposes, like for researches, those are not allowed, because those will give you a market advantage before the patent expiry, and much more before the patent expiry. So that will be, in quote, cheating. So those are the things not allowed in the Bolar exemption.
So we already define and discuss what are allowed and what are not allowed for the generic companies. But of course, it is a kind of balance, right? Between the originator companies and the generic companies. The system preferring or intending to make these drugs available for the society. So we want to make it, in a lower price in terms of the selling price of the drugs. So what is the implication, or what are the results of this Bolar exemption for the society? What can we say for the societies or patients' life?
Well, of course, in terms of patients, it is an advantageous thing, because access to drugs are getting easier and easier, and cheaper. So, in terms of public health, and this is also what makes this subject so fragile. I mean, because on one side there is investment, and high amount of investment, and investment in terms of labor, but on the other side there comes the public health, and what a drug aims is to improve the public health, to treat the patients, both humans and animals, and therefore it is of course an advantageous and important thing for public health. But when we only focus on public health, we will be hindering the innovation. Then the innovators will stop investing in those researches, because to give some numbers, those are not of course apply to all drugs, but there are like between 50 and $100 million of investment in a drug, and it takes 8 to 10 years for the development of a drug. But on the other hand, when the conditions are, available, a generics producer can produce the same drug for maybe $1 or $2 million and like in a year, because they will have the access to many data as well, and they will have this advantage. Thanks to Bolar Exemption, they will complete all the experiments that needs to be carried out just before the release of the drug, so they will have the advantage. And therefore, as you said, it's all about a balance. I mean, it shouldn't be biased. But right now, as it is not yet implemented in an ideal way, it may be sometimes, maybe Ecem will talk this about later, it sometimes can be biased in one way or another.
So the balancing is critical, but if I am just imagining myself as an originator company, if I invested millions of dollars to invent a new molecule for a drug candidate, and if I am trying to manufacture and sell in the market, so I will expect high amount of return of investment. But this Bolar exemption, of course, will be good for generic companies to make it accessible in a larger scale, in a lower prices. But in terms of patent originator company, how can I continue to exclude the generic companies, even my original patent is expired? Are there any abusements, or are there any other strategies for the patent owner companies to exclude the generic companies?
Yeah, so this is actually, maybe we will talk about these issues right now as well. One of the, implications of the Bolar exemption, in my opinion, in terms of innovator companies as well as the ecosystem, one of the ways they will try to achieve that is evergreening. They will keep trying to extend their protection period and then, enforce their rights, which is, it's arguable, it's controversial, of course. But as you have stated, it is important to see their point of view. And, commercializations of an original drug, really burdensome, really expensive, takes a lot of time. And, there are already limitations to this. Like patent term is limited, and then there is Bolar exemption, and sometimes, maybe we will talk about that later, but sometimes they cannot even patent it and they have to benefit only from that exclusivity. Like, there are already limitations in place, and if they are used correctly, like I have stated, like if the generic company is on the market day one after the patent protection, it works. But earlier, it will not work, in my opinion. It will not be fair.
Bert, what do you think about that?
Well, that is also, a discussable subject, but I would also like to add the supplementary patent protection, which also, helps the innovator to keep their monopoly right as well. Therefore, back to your question, there are also some different systems that helps, supports the innovator as well. Like Ecem said, evergreening or data exclusivity or supplementary protection, though it's not applicable in Turkey, but yet it's still a right that is, on the side of the innovator.
So can we say that there are some gray areas or some points of legal uncertainty in Bolar exemption? Can we say that?
I believe so. I think we can say that in terms of, there are gray areas regarding application and interpretation of the Bolar rule under Turkish practice. So original companies will mostly try to act against the generic company, and they will try to do so before their drug's price decreases. Because once the generic drug is on the market, the price of the original drug will drop down by like 40%, even if it is not being commercialized heavily. right? So it's really important to detect it and stop it right before it happens. And regarding the application, one of the gray areas is that sometimes we especially see this in earlier court cases. Sometimes we see that Turkish courts interprets this rule very broadly, and like we understand application to obtain a license is under the scope of Bolar Exemption and not infringing. And we also understand that obtaining a license to sell the drug is not infringing as well, because obtaining a license does not mean that you can sell it. You have still need to have a market authorization. However, sometimes we see that courts interpret acts that are, detrimental to the originator and not a must for obtaining the license, not necessary for obtaining the license, as within the scope of Bolar Exemption. And like broad interpretation of this rule will mean that even though the generic product is not being commercialized, is not being sold heavily, your original price will drop down like 40%, and you will have very little return on investment. And it's really hard to overturn. That's what we see. I mean, you mentioned the gray areas in terms of practice, and however we see in recent cases as well that the Turkish courts decide against it, like the tide is turning kind of recently, and they will accept injunction requests as well as recording of evidence requests. Like what the originator will do is ask the court to examine the file of the generic company's license application. So they will examine it, and then they will determine whether there is an infringement or not. And you can do this with a preliminary injunction. In earlier decisions, courts did not even consider these requests. It's what we see from precedents. And they will, like the court will directly tell you, no, it's within the scope of Bolar Exemption. You cannot ask recording of evidence. And now we see some decisions on the contrary, and we see some decisions even we see some injunction decisions, even like removing the generic drug from the reimbursement lists of Social Security institution. So hopefully gray areas will start to fade, because it's really important in avoiding gray areas as much as possible in a very sensitive subject like this, because it's directly includes like human health, accessibility to drugs. I think there is no room for mistakes. There is no room for differing opinions. And maybe I'm talking too much at this point, but avoiding legal uncertainty in this subject is also very important for generic companies as well, because they are very limited, and being unpredictable environments will cause them not to operate as freely. They will always be under the pressure of infringements, under the threat, and their activities will also be hindered as well. I guess I have made a quick detour, but it's like that in a nutshell.
Before moving forward, may I add something? As Ecem interpreted the subject on the side of the innovators, even though she mentioned the possible risks of the generic producers as well. There are also, we are also always interpreting the subject as an advantage on the generic producer's side. But there is also the risk that, as the exemption is unclear, the generic producer may unintentionally infringe a patent as well, and therefore, result in a costly litigations and also delays in their operations. And also, as the exemption scope differs from country to country, generics producer may again unintentionally fail to comply with a regulation of a specific country. As Ecem said, they can be also overcautious, and therefore there are also risks on the generic producer side as well.
So it can create another bigger problem. Come back to the Turkey. So we have our IP law, and we have some, of course, case laws and some decisions and different courts. But how? I'm just wondering: are there so many infringement cases or different law cases regarding the Bolar exemption in Turkey. And I'm also wondering that how Turkey is eating this yogurt in Turkish say. Comparison with EU and United States. Yeah, we said that different to country in different jurisdictions. So how Turkey is implementing this Bolar exemption? Are there very specific and major differences, or are we obeying the rules like EU?
Right. So, as I've said, we see in earlier decisions of the courts that the interpretation of Bolar exemption is very broad and which is, therefore infringing the originator's rights. And as you have stated at the beginning of this podcast, Turkey is a generics company. And, interpretation of the Bolar exemption actually heavily relates to public policy as well and, overall situation of the country, overall profile of the country. Like various different factors. However, I can say that even though Turkey is a generics country, like I said, in recent decisions, we see that injunctions are issued and requests regarding recording of evidences are accepted, and like the tide is turning, in my opinion, and Turkey is getting more and more aware of originators' rights, and hopefully so. And I'm not, trying to state that Bolar exemption should be interpreted very narrowly. However, I think, aiming for giving the originator duration of protection that they were promised, like 20 years, like in most jurisdictions, should be the, main goal. In Turkey, we cannot definitely say that they are really behind of originators. We cannot say that. But as I stated, we see some, positive decisions in that regard recently.
Also, I'm just wondering that regarding our judges in the IP world in Turkey, are they well educated on this topic as well, or do we have still improvement space for the judges in terms of educational and knowledge level on this topic? What do you think?
So as you know, our judges are unfortunately not from technical backgrounds, which plays a big role, duration of these types of proceedings. Because more often than not, always, I can say always, when you apply for injunction, or when you file a lawsuit regarding, I don't know, patent infringement, patent cancellation, the judge needs to obtain an expert report from an expert panel. They will be the experts, and basically they shape most of the decision that will be given in that case. So, especially for time-sensitive matters, proceedings like obtaining an expert report and such will prolong proceedings, and, acting against generics when you're an originator company is really time sensitive. So like if you cannot stop that in time, your price will decline by 40%, like I said. I mean, that's definitely a hardship.
Exactly. This is another problem. Expert opinions to the judges is another problem in Turkey. So we have already recorded another podcast about this system in Turkey. So this is another topic. So I don't want to dig in the system. So okay, let's come back to the bigger picture of this topic. At the end, the story is coming to the public health. So the people suffering from different diseases need drugs to heal themselves. So originators are investing on the new molecules. Of course, they have the patents, so they need to use that advantage in the competitive environment. So, and then patent expires, and Bolar exemption is implementing, and the generics are emerged to the market, and then they are producing the same molecule with different type or same type, whatever it is. But I'm just wondering that do you think that this Bolar exemption fits into the healthy patent system, including the global health system? So if it is advantage or disadvantage to encourage the innovation or the improving the patent system and also the society. What do you think?
Actually, I think it's a little bit, early to, easily say that it fits into the healthy patent system. But of course, obviously, the reason of this exemption, the reason what triggered this kind of exemption, the need, is that it's a good thing. I mean, it at least aims to be a good thing. I mean, it aims to preserve the integrity of the patent term, and also the exemption respects the full duration of the patent. It does not permit early commercialization. I mean, it only permits early regulatory preparation. And also, the innovator still enjoys the exclusive market rights until the expiry of their patent. Of course, as we said many times, it helps developing public health and, gives access to drugs, and it becomes easier and cheaper. In case interpreted in an unbiased manner, it also encourages early and efficient competition as well. And by clearly defining what generics can legally do pre-expiry of a patent, then Bolar would help prevent accidental infringement as well. So in the end, it's a good thing. It is going to be a good thing in terms of both on the side of the innovator and also both on the side of generics producer.
So it's a very complex process, and every complex process needs deep expertise. But as far as I know, these both sides, the generics and the originators, they are always working with experienced patent attorneys, even in Turkey or United States, in Europe. So I think the role of patent attorneys are really important on this process, right? To guide both sides, giving the strategies or creating a new approaches, new strategies to get the advantage on this competition in regard of Bolar exemption. So, what do you think about this the role of patent attorneys? So, what can we suggest to generics and the originators?
Well, I totally agree with you, and that's the reason why we are here as patent attorneys, to help both sides protect their rights. I mean, on the side of the innovator companies, maybe drafting strong and enforceable patents are really important, and strategically structuring the claims to limit the reach of the Bolar protected activities, and also management of the innovator company's patent portfolio, as Ecem said, help develop evergreening strategies. If applicable, pursue supplementary protection certificates, to extend the terms, and also maybe most importantly, monitoring and enforcement of the rights, track the competitor activities who may claim Bolar protection. Also, one of the most important things is assessing whether testing or production activities cross into infringement. And other than that, advise on this Bolar abuse maybe, and advise on the gray areas as we spoke.
Right. The most important, in my opinion, is like consistent and obsessive monitoring, because, like I've said, this process is really time sensitive. So it's really important to act very swiftly in order to get a better result. And then on the flip side, by the way, regarding generic companies, what patent attorneys can do is to maybe like conduct really extensive freedom to operate searches, like to see the valid and enforceable patents and stuff.
Yeah, exactly. This is the main part of the game, right?
Yeah.
Yeah, they can also maybe prepare legal justifications, and also maybe they can learn and implement jurisdictional requirements on the side of the generics producer.
All right, so we are almost more than 50 minutes in this podcast. So I would like to come to conclusion slowly, not slowly, in a fast way. Of course, as we said at the beginning, in Turkey we have full of generic drug companies, pharma companies. So in terms of this, this Bolar Exemption and other supporting regulation and other things. As an experienced patent law firm and IP lawyers and engineers, what can you suggest or how you can guide patent professionals or IP professionals working in pharma companies in Turkey? So they need to be careful. They need to create their strategies in a careful way. Ecem said that freedom to operate is the critical part in this game. So, but we should say something as an advice to these Turkish pharma companies. What do you think as a takeaway?
You mean that like Turkish pharma, the generic drug companies?
I wish to have original drug companies, originator drug companies, but yes, I mean the generic companies in Turkey who are trying to produce the original drugs with using the Bolar exemption.
Right. Right. So as I've stated, like conducting freedom to operate searches is very important, as well as respecting data exclusivity, which means that like it's kind of an IP right, not exactly a patent. You have to respect that as well. You cannot like obtain sales approval before the expiry of the data exclusivity, and also maybe contribute to the ecosystem. And I am aware that certain generic and biosimilar companies are like as a company policy and like never wavering company policy, they are really mindful of others' intellectual property rights, and they are really respectful. They are trying to like not infringe, and it takes two sides. And I think that generic companies maybe can contribute to that as well.
And also for the innovator companies, I can say they should develop a proactive IP strategy maybe, and enforce selectively, not aggressively. And it's really important to monitor properly and know your rights. And also litigation readiness is also a complement to this mindset of knowing your rights on what to do in case of such infringement possibility.
Exactly. But the thing that I really observed in Turkish pharma industry, still we need to develop the patent knowledge in terms of patent searching, in terms of the finding the legal information from the patent documents, creating a very strong freedom to operate searches, and doing the periodic and sustainable patent searches from different databases, using the paid patent databases, because not all of the informations are written in the free databases. So these are still the missing points and very open to developed for our patent professionals in Turkey. I'm not sure. I don't know if you agree or not, but this is my observation from the ground.
No, I definitely agree with you. And thanks to you and people like you, the knowledge about these very important issues is also like strengthening day by day. I think that like knowing IP is not just privy to professionals working in this field. I think like if you're a business owner, you can utilize IP. You can conduct business deals. You can find new partners. You can force competitors to buy from you. So as a general note, I think it's really important as well. Thank you.
Exactly. Thank you so much. That's why we are recording this podcast, to improve the knowledge level of our audience in the Turkish and of course in global environments. We know that there are lots of audience and listeners from out of the Turkey as well. So Mert, do you have any additional comments as a takeaway, or should we coming to the closing the session?
Well, no, I guess not, but I want to thank you as well for doing what you do. Patent effect is really important for Turkey and for the IP ecosystem, both in Turkey and for all over the world. And thank you very much for having us here and letting us have the opportunity to speak on this very important matter. Thank you.
I also thank you for great insights. So, for our audience, you can find the LinkedIn profile links of Ecem and Mert, and also you can find the website of Simaj on the description of this episode. So you can always reach them and approach them to ask your questions, or even you need a technical or legal needs. So I think we should come to close the session. It's all about the 1 hour. It's very comprehensive topic. We can talk hours and hours, of course, but we have to stop in somewhere. Thank you so much for being with me on this podcast. Of course, as you said, Mert, as Patent Effect, we are trying to improve ourselves and increasing the number of our, target audience in Turkish IP ecosystem. So we recently exceed the, 10,000 members in our patentraporu.com. So we are keeping on this topic. So I hope we will increase the number of audience as a double maybe next year. So let's close the session. So thank you so much, Ecem and Mert, and hopefully we will meet in somewhere in an in-person meeting or conference or somewhere else in the world or in Turkey.
Yes, thank you. Thank you. I hope we meet in person one day as well.
See you then.
See you. Thank you very much.
Bye-bye. So we had a great session with my distinguished friends and colleagues, Ecem and Mert from Simaj. And we recorded this podcast session with the help of, and of course with the support of Simaj, who is one of the main sponsors of Turkish Patent Landscape Report. And I hope you also enjoyed and you also learned a lot from these two speakers' insights and information from the ground, from the legal perspective. And I hope to meet you with another next episode in an upcoming days. So take care and see you next time. Bye-bye.